petitioner appears self-represented pro se, the respondent and appears by Zoom. The respondent appears by Zoom and with her counsel, Mr. McClendon, who's recently entered this case as of May 11 of 2026. We had a review hearing set for May 15th. There was a request for continuance on May 14th, and the case was rescheduled for today. The notes indicate that there was a Rule 170 filed, but not journalized, perhaps, but this has been quite an ongoing case, Mr. McClendon. I mean, they've been through numerous attorneys. They have been through collaborative resources. They have self-represented extensively. They have litigated self-represented. They have met with their respective spouses together and did their own mediation. And we're still back at it, I guess. And the last that I knew, there may be much more now, but there was a real issue with medical information and the need for ADHD medication and changing that medication without notice and all kinds of things. So I don't know where we stand today and what you're ready for. Mr. Jansen sent some information to my AA, but it was some stuff from a teacher that was not in affidavit form, dated, authenticated. I mean, it was not evidence I was going to consider outside of a hearing. But given the current situation, your evaluation of the case, where do you think we stand with this case? Because frankly, I am ready to send them to a case manager indefinitely for as long as I can. Now there's a limitation, I think, on that. In other words, you can't do it indefinitely. And I don't remember if it's a year or 2 or 3. I'd have to look at the new rule, but I'm really inclined to set them up with case management. If they can't refine their arguments and settle some of these things, and in the alternative, at some point, there has to be an end so that they're required to file motions to come back before the court instead of just continuous court dates. But I'll hear from you in terms of your assessment and where you think we're at.
Well, Judge, just talking between the parties, and granted, I've only had maybe a 10-minute conversation with Father, but I think the parties have reached an impasse in regards to custodianship and child support. I think both parties want the kids to go to school in Fredonia. Mom lives in Fall River, dad lives in Independence. The problem with dad living in Independence, and this is my client's position, but a 40-minute drive every day to school is kind of unreasonable. So a judge, I think we just need to set it for a custody hearing, a custody determination, and I think that would help get the ball rolling on these types of things.
Once it's been litigated, there has to be a material change of circumstance, and I don't know that either one of them have proven that. So I need to look back here and see if we have a setting that qualifies for actual trial litigation. I know we were set for trial at least once with Mr. Jansen. And maybe that's when something happened and he pulled out. There were objections to the DC report. We went through very detailed, what they had agreed to and what they hadn't, what they took issue with. We tweaked it. They confirmed it. We had a trial set to 20/26. Okay. Well, I need the parties to understand this. Once we go to trial and I make a custody ruling, it will be very hard for you to show a material change of circumstance that would warrant a new trial, custody litigation, or changes in that parenting plan. So you may get what you want and be very happy that it is a permanent plan that's going to remain pretty permanent, or you may be unhappy and be stuck with the plan for a very long time. So I think you both have to think about, you both could lose. I doubt you both are going to win. One could lose, the other could lose, but once I do finally give you a full trial on the matters based on what all has been done and worked on so far, that will be the presumptive permanent parenting plan that would warrant a very material change of circumstance for any modification, because the law does not favor continual custody litigation over children. So the way the law does that is, once you've had due process and a full trial and a ruling by a judge, any judge in this state, who has fully heard both sides and the evidence, and it's not a plan that the parents put together, but one that the court ordered after a trial, then it takes a material change of circumstance that the court views as material enough to make any changes to the parenting plan whatsoever. So I'm just suggesting to you that you two are going to lose your power in a lot of this, and you may or may not like it. Now, I'm not threatening you. I'm not suggesting, that my intent would be to make either one of you unhappy. I just want, this has been an ongoing situation for quite some time, and pretty contentious, and one that really qualifies for case management, which would be somebody that you constantly go to, that if you didn't agree, they would make recommendations, you would accept them, or they'd send them to the court, and pretty automatically the court accepts them. So it would be one experienced person with the qualifications to be a case manager. However, you have a right to a trial, one trial. And then after that, it's, a matter of discretion to some degree, whether or not you're going to get a full new de novo type of trial on custody again. So, I feel, looking over your case from what I can remember and what I see, as much proper argument, providing of tons of documents by both sides. We've not been in a courtroom with a court of record, where live witnesses have appeared, and there's been a court trial, that if the court, when the court would make a ruling from a trial, it would be appealable by either side for 30 days, and otherwise it would become final and permanent. I don't see that we've had that. Amy, if you disagree with me, let me know. I'm not going to be able to give you a trial date before school starts. So the kids are going to have to stay in the same school that they've been in. I do, for whatever reason, currently have September 9, 10, 11, 14, 15, and 16, and 18. And I think that this is one we should plan a day and a half, if not 2 days, so that we don't run out of time. So if you look at your calendar, Mr. McClendon, that would be in person, Greenwood County. I do not have the ability to do bifurcation. Or not bifurcation, I'm sorry, hybrid. So there cannot be any witnesses that we can plan on to be by Zoom at all. They will all have to be subpoenaed. They will all have to be in person, without exception. And, you know, again, on a lot of occasions with these parties, there have been proffered documents. We will get people on by Zoom, you know, done everything in my power to try to accommodate everyone. But when we go to trial and litigation, there are going to be rules of evidence and there's going to be requirements. And one of those is I cannot ensure that I can accommodate a hybrid hearing in Greenwood County. And this will be an in-person trial with everyone appearing before me under oath in person. Okay? So now there is a court rule. There is a new Supreme Court rule. But the problem is we cannot assure someone that counts on a witness appearing by Zoom that we're going to be able to technically facilitate that for everyone to view, see, and hear. So I wouldn't count on the court granting anything under the exceptional Supreme Court rule that allows for video testimony. But you can look at the rule if you want to. All right.
Judge, have these parties already done some form of case management?
Not case
They have.
They've done exhaustive DC
Mediation.
domestic conciliation.
Okay.
Through they did a mediation that was confidential. They did domestic conciliation with 1 or 2 people. I think just collaborative. Yeah. Out of Andover. If you want to get any of these records, let me know. There's a very lengthy collaborative, overall assertion of what their agreement was, and then the things that remain, and then very pointed objections and arguments as to what they didn't agree to, and then an effort by counsel and the court and then the parties to narrow the remainder down, because there were things that they did agree to, the remainder down and try to come up with a permanent parenting plan. But any of those records that you want to make copies of that I may have in my file, you are happy to let us know and obtain. So I do think you'll need a little bit of time to get up to speed on the case, and of course, time to issue subpoenas. So in looking at the week of the 8th, the 7th of September is a holiday, is Labor Day. So looking at the week of the 8th and the week of the 14th, are there
I can do the
couple of days?
9th and I can do the 9th and 11th, Judge. I have a termination hearing in front of Judge Lee on the 10th.
Okay.
But I can do that Wednesday and Friday. The next week does not work for me. Well, so we could, I think my pre-trial day on that, let me see real quick. is August 25th. On that September 10th date.
Yeah,
I do. So it's kind of a mother's last shot of redemption kind of thing. And I fully expect us to have a termination hearing.
Okay.
If mother doesn't get things together. So
so, let's go ahead and mark out the 9th, 10th, and the 11th of September, 3 days for trial. If you end up in that termination case, do you try those in Judge Webster's courtroom, or do you go into the district courtroom?
it'll be courtroom there at Butler County Judge. It'll be
Oh,
in
it's a
Judge.
Butler case.
Yeah.
Okay.
Yes, Judge.
Okay. All right. So what will happen is if the 10th frees up, we'll carry over into the 10th. If the 10th doesn't free up, we will resume on the 11th, if you can't do 2 days in a row. Otherwise, we end up, if you can't do the week of the 14th, then we end up in November 9th and 10th.
I think those days will work just fine, Judge. Are you wanting to start at 9?
Yes, they're at Greenwood County Courthouse in person. We have to verify that the courtroom's available, but I imagine that it is.
It is. I've already looked.
All right, great. All right. Now we need a pre-trial conference. So trial, September 9, 10, 11. Pre-trial conference. Has to be no sooner than 2 weeks previous. We can do a pre-trial conference on Friday, August 21st, Monday, August 17th, or August 11th. Is August 11th the first day of school? It is in El Dorado, I guess.
It should be about August 19th or 20th. It's usually around the 20th, and they usually start on a Wednesday.
Okay. So do you want to have a pre-trial conference on Friday, the 21st? Or the 17th or the 11th of August?
Any of those days really work for me, Judge. Just
All right.
depends on time. I'd probably prefer the 21st.
Okay.
If we want to set it for like early afternoon, 1 o'clock.
Okay, perfect. All right, I'm gonna set this for a pre-trial conference on Friday, August 21st. That will be by Zoom at 1 p.m. for an hour. So we can take up any motions or issues that have developed with regard to anything to do with the actual trial. Okay. 21 DM 54 1 hour. All right. We are set.
I just have one question, Your Honor.
Uh-huh.
So are we, the case management, is the trial in lieu of that? Like, we're not doing that? Or,
Yeah, no, I mean, if they're demanding a trial, and you know, I don't think I can order, I should order. I got to have some finality with some of this stuff. I don't think that I should order case management where there was never an actual trial. I think there needs to be a trial, as I indicated. Unless you wanna, waive trial and go to case management, that's fine. I don't have a case manager in mind. I would have to do some investigating as to who's out there. But, if we do a trial, down the road, you could still end up with a case manager, but if we do a trial, then that provides permanency, due process, and an inability for somebody to argue that they've never had their actual custody litigation trial.
I understand.
So
And the
as much
last,
as I'd like to go to case management, I just don't, I think there ought to just be some final litigation here. We've prepped for it numerous times. Or this is gonna be ongoing, and it's not healthy for either one of you or the kids. So, yeah, no case management at this point.
right, and lastly, Your Honor, if we're going to continue trial back into the school season, I think we might need, another temporary parenting plan during the school year. Just to mitigate any problems, because right now it's on the permanent parenting plan for every other day, but I think we've all agreed that's not good for them.
Mm,
Well, what were you doing last year during the school year?
It was every other day until we had the temporary order from you for 2 weeks on and 2 weeks off.
Well, I don't, you're not gonna like this, but I think you're gonna have to do 1 week on, 1 week off.
I'm fine with that. If,
we already talked about it. That was still too much. It's still too much back and forth. It took Henry anywhere from 3 to 4 days to reset himself with the 2 weeks, 2 weeks.
Yeah, I don't know. 2 weeks is a long time, in my view. To be with one parent, not with the other. So,
I mean, honestly, Your Honor,
I-
it was a long time, but I think they handled it pretty well, like.
well, I mean, all I know to do is to revert back to the previous school year schedule. If this was contemplated to be a summer schedule of I mean, I don't think, given your circumstance with your kids, either one of you are gonna argue that every other day is appropriate for them and in their best interests.
Mm-mm.
At least the one son, during the school year. Right?
Yeah, no, that would not be good at all for them,
Okay,
especially the youngest.
okay. So let's go back to the 2 weeks on and 2 weeks off in the previous schedule until we can figure out. It's highly likely when I hear this case that I'm going to do a plan that covers everything. That maybe means somebody gets less time. But that doesn't shift around a lot in the summer. So whatever that looks like, again, be prepared that you may not get every other day in the summer. And you may not get a full 2 weeks at a time. And so, and I am going to need more testimony than just one of you saying, this is what happens when he comes back to my house. This is what happens when he comes back to my house. Now, you have provided teachers information and, there've been physicians involved with medication and all that kind of stuff, but you're gonna need some independent resources to confirm the negatives associated with the exchange. And if I agree with you, that means somebody's gonna get more time because there's gonna be less time exchanged. I mean, we're gonna get a plan that encompasses the whole year. It's not gonna be a temporary plan that we're gonna change next school year, or a temporary plan that's only good till the summer, or any of that, okay? So I really do want to provide you with some finality that you're gonna have to live with, that you may or may not have all the input that you'd like. And you may not view it to be in the best interest, but I'm gonna just have to do my best job based on what I have before me at the time. Okay? Mr. McClendon, if
Yes.
you could look at that, and if we simply could reinstitute the school year plan easily enough to get us, through the first part of August, I would appreciate it.
I can do that, Judge. And then additionally, we need to address the pickup and drop off location. It seems there's been some issues in regards to that between the parties. So I'm not sure where we were at. I saw a journal entry dated, or it might have been a December 24th, 2025, coming from Mr. Johnson's office as a journal entry. This stated there'd be a pickup and drop off location at the Fredonia truck stop at the roundabout in the summers. That's not being followed currently. And I would ask the court to reinstate that and make that clear, both parties.
That was, no, that was the suggestion, because we hadn't agreed on anything yet.
Oh, was it? No, that it was in a journal entry of hearing, Your Honor.
It was, when we had the final hearing on the last motion I'd filed, it was May 22nd, 2023. When Mr. Jansen had moved and we had all that talked about, he had asked to have the pickup and drop off location moved to Fredonia. And
Okay, I'm gonna do it one of two ways. You guys are gonna meet at a halfway point, and that's pretty easy to figure out. If I take your two addresses, a halfway point in a public location that's got good lighting, that isn't dangerous. Or I'm going to have whoever's getting the child for their time transport the child to the other person's house. So when it's your 2 week, you go to him, you get the children, you go home. When it's his 2 week, he comes to you, gets the children, and goes home. And if you can't do it at the house without, having a ruckus, then it will be the closest police station or public spot closest to your house.
During the school year, we met at the roundabout in Fredonia. It was perfect halfway point between the two. I'm okay with that. We want to continue it.
Okay. Well, if that's what was in the last order, Mr. McClendon, that you have, that's what I'm trying to just kind of resort to de facto what we had, maybe not what was in the works, but the last orders that we had on file.
Your Honor,
Till we get to
Oh.
trial.
the
Yep.
last orders that were on file is from the very original one when he was still living in Fall River. And it wasn't specified because it was understood that since we both lived in Fall River, that it was in Fall River.
Well, but what about the 2 week on, 2 week off? What were you doing with that one?
That one, the children were able to ride the bus back to my house, and on his days, he had picked them up from school. So there wasn't actually any direct exchange between us.
Okay,
And whenever we did have direct exchange during school, we met at the roundabout in Fredonia.
No, we did not. It was attempted, but
Mm.
nothing was actually finalized. it was still in discussions.
Okay. Where, Mrs. Graham, where is a place next to your residence that you could get to in a few minutes to have the kids if you don't want him coming to your residence?
There's the grocery store that's right here in town.
What about you, sir?
There's a Casey's gas station right down the street from my house.
Okay, those are the two places you're gonna exchange. When it's your time to get the kids, go get them. Okay,
Good.
What's the address of that Casey's? I don't want,
okay, good idea. Let's get that.
and do we want to set a specific pickup time? I think I would like to have that in order as well, Judge.
Okay. There's something I signed here on February 2nd of 2026, journal entry of hearing Mr. Johnson submitted that says that Amy just brought to my attention exchange location, drop off and pick up during, school drop off and pick up. Summers, Fredonia truck stop by roundabout.
Mhm.
Exchange locations, drop off and pick up. Summers, midpoint, Fredonia truck stop. But it's not summer. And school drop off, are you doing the exchanges on the weekends?
Normally, whoever weekend it is, they're the ones who gets them from school. And they're the one who gets them to school on the Monday or whatever day follows after the
Okay.
weekend.
All right. What if it's what if they're out of school?
Oh, like if they have like a Monday off or something?
Yes.
Usually whichever parent has them would have them for the extra day. It would just be treated as like an extended weekend, and they would get them to school the following morning.
So that's your choice. What I just ordered, or you're gonna do till school starts at the midpoint Fredonia. And then when school starts, the pickup and drop off will be at school. So. Those are your two choices. I think that we ought to stick with this last journal entry as if I'm gonna do what I said, which is I'm gonna default to all previous orders. And consider them as the de facto or current. Well, it is the current court order situation. Then we're gonna do the school exchange and the roundabout until school starts.
Your Honor, if I
Yes.
may, at that last hearing that I specified, May 22nd of 2023, I've been trying to get the end of that. For some reason, the recording was cut off early.
This is February 2nd of 26.
I understand. I understand. At the end of that hearing, Mr. Jansen had asked if we could change the pickup and drop off location to the Fredonia truck stop, and you had.
I don't
stated that-
care. I don't care about a 23 hearing. I don't care about anything. I care about, this is the last court order. And it's very specific on transporting. And it's when school's in session at school, pick up and drop off. And when it's not, it's at Fredonia roundabout truck stop. That's my order. Okay? All right. Unless you need something with me with regard to trial, we are adjourned. Thank you.
Your Honor.